Can you defend yourself against a child who is under the age of criminal intent? I recently had a conversation with someone who told me that their wife is having to have her neck surgically rebuilt with bone taken from other parts of her body. The injury was caused by an 8-year-old child violently pulling the member of staff's hair, causing the person's head to jerk back violently. More recently in the news, a teaching assistant who was punched, pinched and kicked by a 5-year-old boy in her reception class has been awarded £140,000 in compensation. Now, generally speaking, a 5-year-old or 8-year-old child will be classed as a minor and possibly even categorised as vulnerable due to their young age. As such, any training given to staff in the schools they attend or the care home they reside in to enable staff to control and restrain them may be low-level training, involving techniques that are designed not to cause any harm to the child. But where does a member of staff stand if they are violently attacked by a child, someone under the age of 18, who may also be under the age of criminal intent, which is 10 years of age in the UK and 12 years of age in Scotland, if the techniques they have been taught don't cater for such an attack? This is important to know because someone under the age of criminal intent cannot commit a crime in the UK, but they can still behave violently, as we can see from the above examples. So if a child is attacking you, can you act in self-defence against the child? This is a question I was recently asked by a retail shop owner who had a teenager in his shop who was threatening him and other staff members with violence. At one point, he even threatened to kill him. And I know this firsthand because I was there. Now you may be probably thinking, why don't they call the police? They did, but the police didn't respond. I also called the police and they said it wasn't a high enough priority to dispatch officers to, even though there were threats to kill. In the news today, the BBC News and national newspapers are running stories on police response times which show that officers are now 28% slower to attend a Grade 1 emergency response after receiving a 999 call, according to data released by 22 of the 23 forces, and detectives are 44% slower to arrive at such incidents than 9 years ago. Responses from 19 forces to Freedom of Information requests by the BBC found. So what about the school or care home that only trains staff to a low level of control and restraint and who would rely on the police attending a more serious incident? And what is a member of staff allowed to do if they are being violently assaulted and their training doesn't work, or such defences to violent assaults weren't covered in the training? What the law says. Section 3 of the Criminal Law Act 1967 states that a person may use such force as is reasonable in the circumstances in the prevention of crime or in effecting or assisting in the lawful arrest of offenders or suspected offenders or of persons unlawfully at large. As we've already stated, however, a child under the age of criminal intent cannot commit a crime. But with regards to self-defence, the law does not distinguish a lower or upper age range for who you may need to use self-defence against. It doesn't state, for example, that a person may use such force as is reasonable in the circumstances in the prevention of crime or in effecting or assisting in the lawful arrest of offenders or suspected offenders or of persons unlawfully at large, provided they are between 18 and 65, for example. This is where the common law applies, and the case law on this is Palmer. In Palmer, it states, "It is both good law and good sense that a man who is attacked may defend himself. It is both good law and good sense that he may do, but only do, what is reasonably necessary." With regards to what is reasonably necessary, the first question here would be, was it necessary to use force in the first place? Or were there other options available, like moving away from the child and or leaving the situation and or place of work? If it was necessary to have to defend yourself, then the second question would be, is what you did proportionate to the harm that you prevented? So if a child was threatening to kill you, as in the retail example, and moved towards you whilst reaching into his back pocket, making you believe that the child had a knife, and you struck that child in the face, causing the child to fall backwards and suffer a broken nose, I would argue that the action taken, given those circumstances, was reasonable. Now there are two tests here, a subjective test and an objective test. Subjectively, the action taken would be considered in relation to the facts believed by the person who took defensive action. The objective test is what would a reasonable person think given all of the facts in those circumstances. In other words, would a reasonable person think that the defender acted reasonably given the facts and circumstances? And what if the person defending themselves made a mistake? Let's say that after the event, it transpired that the child didn't have a knife in their back pocket, but reached behind them to scratch their lower back. The general approach to the law is that it allows such force to be used as is reasonable in the circumstances as the defendant believes them to be, even if his belief was a mistaken one, and if so, even if his mistake was an unreasonable one. In the case of Williams in 1987, the judge, Lord Lane, concluded that even if the jury come to the conclusion that the mistake was an unreasonable one, if the defendant may generally have been labouring under it, he is entitled to rely on it. Lord Lane, CJ. So provided that the mistaken belief was a reasonable one, there is no issue there because by law you are innocent until proven guilty, and it is for the prosecution to prove any guilt beyond reasonable doubt. One thing I will say before I finish is that once the threat is eliminated or reduced, any further defensive action may be considered an assault. So going back to the child threatened to kill you, if you use force and that stops the attack or believed attack, then you can't justify any further action like kicking the child while they're on the floor, especially if that further action was motivated by some form of revenge or retaliation, etc. But the bottom line is, everyone in the UK has the right to defend themselves and go to the defence of others. And this right extends to defending yourself against a child of any age. If you have any questions, please don't hesitate to get in touch. Feel free to leave a comment below, and if you wish to share this in the hope it will help someone else, you are most welcome to. And if you'd like to qualify as a properly trained BTEC Level 3 self-defence instructor, you can find out more about that here. www.nfps.info/BTEC-level-3-self-defence-trainer. But I'll leave the link below the video somewhere, or below the blog post in a comment box, so you can click on the link and find out more about that course, and get in touch with me for a chat if you like. Okay, have a good